The final argument today is in case number 18CA011337, All Pro Freight Systems versus Marvin Walker et al. Mr. Walker did not file a brief. He is not present. Attorney Baronick, is it?
Yes.
Is present for All Pro Freight Systems. He is arguing on behalf of the appellant and will have 15 minutes. As you know, these are recorded and posted on the YouTube, so please keep your voice up. And we've read the briefs and are ready to proceed if you are, sir.
If it pleases the court, Stephen Baronick on behalf of plaintiffs All Pro Freight Systems and Chris Laws. We're here today based upon a ruling by the trial court which dismissed, or rather stayed the action when it ruled that that court did not have jurisdiction. The opinion, this was somewhat of a strange case in that when we initially filed the complaint, there was no response by any of the defendants. A motion for default was filed, a hearing was scheduled. The defendant, Marvin Walker, did show up to that default hearing. At that hearing, the court gave him about 3 weeks, I think, to file a response, but instead, on that particular day, he filed a handwritten 2-3 sentence motion essentially indicating to the court that he wanted the action to be moved to North Carolina where he resides. And the only thing he really said in the motion was that that is where all the parties, I think he meant defendants, all the defendants reside, and that's where all the transactions occurred. That was a sum total of what was in that motion. In responding to that motion, I took it as being a motion to transfer the case because of forum nonconvenience. And I believe that the trial court interpreted that motion filed by the defendants as well to be under that motion. The court then issued a ruling after a response was filed by Alpro and Mr. Haas. And the ruling was a little bit disjointed in that although the court does go into a forum nonconvenience analysis of the case, of the situation, ultimately it ruled that there was no proper forum in Ohio for this particular case, which is contradictory to the entire notion of a forum nonconvenience argument, because that doctrine assumes that the jurisdiction in the present court is proper, whereas the trial court in this case decided that no, not only is it not proper here, it's not proper anywhere in Ohio, and in so doing, it made, I think, some leaps in terms of what it assumed the facts were.
So you're saying you should have started off with the assumption that jurisdiction in Ohio was proper before applying the private interest and public interest factors?
It does. It goes hand in hand. I mean,
are you saying that's where the court erred, though, and not making that assumption?
Well, that's one place, yes. Yes. The court, because if the court is going to say, if you're going to apply the forum nonconvenience analysis, okay, even putting aside the error that the trial court said that no proper forum exists in Ohio, but if you're going to undergo that analysis, the burden to provide evidence to the court to enable it to balance all of the public and private interest factors is on the defendants making the motion. And as you know, there was nothing except a 2-3 sentence handwritten motion filed here. So there was really nothing presented by the defendants who had the burden to make the case with the trial court.
Well, counsel, the court says in the second paragraph of its entry that it says it's notable that that neither to the complaint nor the motion, which the motion I guess would be the defendant's motion, so I'm not sure, was a copy of any contract attached. So, and I haven't read the complaint, but are there allegations in the complaint sufficient to show that there was a contract between the two parties, or is the court left at the filing of this motion with there was a dispute here about a certain amount of money, which could be contractual dispute or otherwise, that may have meant the trial court went into the forum nonconvenience because there was just no basis, no way for it to determine what the legal claim for these monies was. Does that make sense?
I think so, yeah.
Okay.
I think so. There was no contract attached to the complaint because this was an atypical kind of transaction. It was done, to the extent that there isn't anything in writing, it was basically done through some emails. And what happened was, and I think this is outlined in the complaint, was that initially Mr. Haas, through his company, All-Pro, agreed to loan the money to Mr. Walker and his company, and then there was a change in relationship between those two gentlemen. And then because they were then going to, Mr. Walker said he didn't want to be involved with Mr. Haas anymore, and the response was, okay, fine, but give me, pay back my money that I loaned you. And then there were emails from Mr. Walker acknowledging that debt and promising to pay it. So that's the whole extent of what there exists.
Okay, I see. Because the court goes on to find that the complaint does not say that these individuals had an oral contract. And without a written contract, I understand, is there reference to specific emails, even though they wouldn't be they weren't attached in the complaint, regarding the agreement becoming a contractual obligation?
Well, I know that there's specific reference in the complaint, Your Honor, to emails that were sent from Mr. Walker to Mr. Haas.
And we can take a look. I don't want to take
Yeah.
up too much of your time, but I was just trying to go through the process because it seems to me that the reason why the trial court went into forum nonconvenience analysis is because it's saying, I don't have a place to start. I have to do this.
Well, and to that extent, and I understand, because of the particularities of this case, my only point to that would be, that's fine if you're going to go into that analysis. But if you're going to go into that analysis and base your decision upon that, well, then you've got to go through those factors, and you've got to hold the defendant to their burden of providing evidence to enable the court to go through that analysis. The defendant did not. And then, of course, there is the admonition from prior case law that unless the balance of the factors weigh strongly in favor of the defendant, then there is a preference or a presumption that the plaintiff's choice of forum should control. And as you go through, what the analysis that the court gives, and granted this is not a fully developed record, so there's scant really to go on, but really it doesn't really weigh in favor of either Ohio or North Carolina in this respect. Presumably there would be very few witnesses involved here. I think one would be Mr. Walker himself, both on behalf of himself and the company. One would be Mr. Haas. Mr. Haas is a resident presently of Florida, but he has lived in Lorain County for many years, has All-Pro Freight Systems is his business, so he's up here all of the time. So that's really not a hardship, and plus, he chose this, or he was agreeable to this forum. And then you have a representative from All-Pro to discuss the actual funding of the loan. I don't, if we have it in Ohio, then presumably you have one person from North Carolina that would have to travel here. If you have it in North Carolina, you have two people that would have to travel from outside that jurisdiction to North Carolina. As we all know, technology documents can be easily transferred from one place to another. There is no premises per se to be viewed here. And certainly I would think that the balance, to the extent that there is a discrimination of which locality would have a greater interest in the resolution of this, I think it would be here where the loan was made, where the claim arose, and where both the plaintiff, Mr. Haas, and All-Pro Freight Systems have ties to this community. So I think if you go with the forum nonconvenience argument, I think what is there contained within the motions and whatnot I think that it is clear that based upon the burden on the plaintiff, based upon the presumption in favor of keeping, of retaining jurisdiction in this forum, and just balancing those equities, I think it is clear that the court erred by making some determination that the case should be transferred to North Carolina.
Is this an abuse of discretion standard?
It is an abuse of discretion standard, Your Honor. And I would say that, one of the things that the court did wrongfully was in terms of the jurisdiction in forum, it made the assumption that this venue had been chosen under Civil Rule 3C12, I believe, or I think it might be 3C10 now. But in other words, it's the kind of catch-all provision which says that the claim can be brought in the venue where the plaintiff resides, if nothing else fits above. But we did not allege that in our complaint, and that's not the basis upon which we invoke this jurisdiction. In addition to the long-arm jurisdiction statute, where the defendants had transacted business in this state, there's also Civil Rule 3C6, which provides for proper venue where the claim arose. And as I'm sure the court is aware, there's abundant case law, and I cite some in my brief, which say that in a situation involving a non-payment of money, the claim arises at the place where the payment is to be made. The money came from All Pro Freight Systems, located in Lorain County. Money would have been paid back to All Pro Freight Systems. So, though that is the basis for the venue, it was not the kind of catch-all saying, where the plaintiff resides. So I believe that the judge, although trying to make the best of a bad situation in terms of having a pro se defendant, not a well-developed record, I appreciate the yeoman's task that the trial court did, but I believe that it erred when it made these assumptions and failed to apply the standards which it needed to apply if you're going to undergo a forum nonconvenience argument. And so, for that reason, I believe that the case should be remanded and have the court reassert jurisdiction.
Thank you, Attorney Baronek, for your presentation. The court will take this matter under advisement, issue a decision in due course. The clerk of courts will certainly mail you a copy of the decision once it is rendered, and the opinions are also posted on the Supreme Court of Ohio's website. So the court will be adjourned until October 20th.